So the Federal Court has now allowed leave on one question, wherein the vesting of liabilities, the non-vesting of liabilities and the vesting of assets in the new MAS, which is MAB, whether that constitutes asset stripping of the old entity. Because ultimately we are going to be in a position, we don't want to be in a position where it's going to be a paper judgment for all the plaintiffs. And I think the court rightly has allowed that this issue is properly addressed.
There are similar issues being raised in Australia and so
MAB, I don't know what stage exactly they're at, but I know in China they have brought their suits against the new company as well, but I don't know what stage they're at over there.
New mangsa in China?
Yes, as far as I know.
You're unsure about the position in US and Australia now?
I am not sure whether they have filed a suit against the new MAB, but I know China has.
What are you worried is actually the position of the next of kin of MH370 and MH17?
Correct, yes. And the High Court judge agreed with us. The High Court judge agreed that they should be left in, because this is just striking out stage. The Court of Appeal, however, just took the approach that because the vesting order exists, based on that, it is good enough to strike out the suit against MAB. As it stands, there's no liability to be attached to MAB. That was the position of the Court of Appeal. They went strictly on the vesting order.
So now following the decision, now you have to go back to High Court, isn't it?
Well, we have to have the appeal heard proper. Appeal proper heard. Today was leave. So once we have the appeal proper heard, depending on the outcome, then we are going back to trial. We're only at striking out stage at the moment. So everything is on stay. It's being stayed at the High Court pending the parties being settled first. The striking out at the High Court, even the government departments have filed striking outs. So Justice Zaki allowed those striking outs.
Oh, he allowed the striking outs?
For the government. So we have DCA and the RMAF. So we filed an appeal against that decision and the Court of Appeal agreed with us in part. So DCA is back in, RMAF is out. So in relation to RMAF, we now have a pending leave application here and DCA has a leave application here as well, which is coming up in April.
Okay.
So you see, because the parties are really not settled yet, the proceedings at the High Court have been stayed. DCA remains in. Court of Appeal agreed with us and they are back in. DCA and Government of Malaysia are back in. So DCA have filed an application for leave. RMAF, the Court of Appeal didn't agree with us and said that they should remain out. So we have filed a leave application against that decision. Both are to be heard together in April. Basically, they're taking position at the time of the incident. MAS had insurance and that insurance will make all the payouts. You see, so our position is not threatened.
You could pay damages to the affected parties.
Correct,
right?
yeah. Essentially, we are not sure, that's number one. And number two, that one thing we have also raised in our submissions is the fact that this vesting order, which is based on this Act, will only live for 5 years. Because this Act is only in force for 5 years or until MAB achieves listing, whichever is sooner. So once the 5 years lapses, the vesting order falls, liabilities that remain with the old MAS remain there. All assets that have been transferred to the new company, where does it go? Now all these questions have to be answered and I don't think MAB can be let off the hook so easily. Especially when we take the position that the new company is set up to eventually continue MAS, which is in administration today. What is the purpose of putting a company in administration? It is heading towards winding up. And they say that our argument is speculative. Obviously, we are taking a different position.